Welcome. We're diving into key court rulings that determine when an organization can be sued over unwritten, informal policies. The core question is, when can an organization be held liable for practices that aren't officially written down in any manual or regulation? Proving an unwritten organizational policy is challenging, requiring plaintiffs to demonstrate that a custom is so ingrained it functions as official rule. These standards, often called Monell liability, are crucial for holding government entities accountable when employee misconduct stems from systemic failures, not just isolated incidents. The foundational ruling is Monell v. Department of Social Services from 1978. It changed how municipalities are viewed under federal law. Monell established that, quote, customs and usages, even without formal approval, can be the basis for a successful lawsuit against the organization itself. This means organizations can't hide behind a lack of written policy if a pervasive, informal practice is causing harm. Next, Attikes v. S.H. Crescent Company from 1970 helped define what custom truly means in a legal context. The court defined, quote, custom or usage as a practice so settled and long-standing that, even without written law, it carries the effective weight of a rule. A custom isn't just one person making a mistake. It must be a widespread, systemic practice. A classic example is the 2010 case, Thomas v. Cook County Sheriff, dealing with jail practices. In this case, the court found that a widespread practice of, quote, ignoring medical requests was a custom, despite written policies requiring medical care for inmates. This highlights that an established, unwritten practice can effectively override official policy manuals, leading to organizational liability. Moving to more recent precedent, Porter v. City of Philadelphia in 2020 further clarified the proof necessary. The ruling noted that uncontroverted evidence of an unwritten policy, like silencing certain speech, is enough for liability, regardless of what the written rules say. When the unwritten policy is clearly and consistently applied, the written rules are often seen as merely a formality, insufficient to shield the organization. However, the 2020 case Hildreth v. Butler provides a crucial caution on the level of proof required. To prove an informal policy, the plaintiff must show, quote, systemic and gross deficiencies in practice, demonstrating a deep-rooted organizational problem. The court was clear. One or two missteps by employees is not enough. The practice must be consistent and widespread to prove an official, informal custom. In conclusion, proving an informal policy is difficult but possible, requiring evidence of established systemic practices. The law demands proof of widespread custom, systemic deficiencies, and a practice so settled it overrides any conflicting official policy. These rulings continue to shape corporate and governmental liability, emphasizing that what organizations actually do matters more than what they write.